Fast forward a few years to a case, Lemon versus Kurtzman, decided in 1971. Lemon became famous for reasons I'll talk about in a moment. The case itself involved, it was actually a pair of cases that came up before the court involving Rhode Island and Pennsylvania salary supplements for teachers, basically because religious schools paid less than public schools. What the state programs did in these cases was that they basically gave out a salary supplement so that the religious schools could sort of top up the salaries of their teachers in non-religious subjects, so math, social studies, history, and so forth. Well, the court in Lemon versus Kurtzman says that's unconstitutional. That is a violation of the Establishment Clause. That's aid to religion in contravention of what the Establishment Clause requires. And the court in Lemon versus Kurtzman, an opinion by Chief Justice Berger, set forth this test that was supposed to kind of frame all Establishment Clause questions to come. And the test says that a law has to have a secular purpose, that the primary effect must be neither to advance religion or to inhibit religion, and that the law must result in excessive government entanglement with religion. These are the three parts of the Lemon test. It's what the common law course, up until at least last year, we would have talked about as the kind of framework for understanding what the Establishment Clause requires, that basically the court is supposed to kind of look at this and figure out whether or not a law violates one or more of these restrictions, and if it does, then it's unconstitutional. Later, in a series of cases involving different things, which I'll talk about in a moment, the court kind of tried to re-articulate this under the guise of endorsement, that essentially the court should ask, would a reasonable observer upon coming upon some, say, funding program or whatnot, say, is this an endorsement of religion or not? If it is, if it's government endorsement, that's unconstitutional. If it's not, then it's permissible under the Establishment Clause. Lemon, as again, I have to talk about more in discussion, but it's really kind of the focus of what I want to say here. Lemon itself proved to be, for decades to come, extremely controversial. Why? Because none of the Lemon factors, at least the critics went, none of the Lemon factors or endorsement, none of that's in the First Amendment. The text of the First Amendment doesn't say that. And the critics of Lemon argued it's not what the original understanding of the First Amendment and what establishment of religion, what a prohibition on establishment looked like. That basically the court in 1971 came up with a series of tests that were extra constitutional, non-constitutional, weren't part of the original understanding or text of the Constitution. And as I say, this proved to be tremendously controversial for decades to come.